Okay. Welcome to this docket of the Kansas Court of Appeals. I'm Karen Arnoldberger, the Chief Judge of the Court of Appeals, and I am presiding judge of this panel today, which simply means I am the timekeeper. Joining me is Judge Kim Schroeder, who hails from Hugoton and was a district court judge in that area of the state for many years before he joined our court. And we're fortunate also joining us today is Senior Judge Richard Walker. Judge Walker was a district court judge down in the Newton area for many years. And when he retired, he was gracious enough to agree to stay on as a senior judge for our court. So we appreciate having him here today. Just a few preliminary matters. We generally don't have the parties go over the facts because we've read the briefs. We know the facts of the case very well. But since these are now on YouTube and anybody could listen to them at any time and maybe not be familiar with what the background is, I will allow the appellant just a few minutes to just very briefly go over kind of what the factual basis is that gets us here today. And I know that the procedural history getting us here today is very complicated. So I don't, just a brief statement that perhaps what we're dealing with here is a preliminary injunction and that sort of thing. So I will allow you that amount of time and not count it against you. So with that, let me first call the case of 121693 Trust Women Foundation, Inc., doing business as Southwind Women's Center, doing business as Trust Women Wichita appellant, versus Mark Bennett, District Attorney for Sedgwick County, Kathleen Selzer-Lippert, Executive Director of the Kansas Board of Healing Arts, Robin D. Durrett, President of the Kansas Board of Healing Arts, and Derek Schmidt, Attorney General of the state of Kansas. So if the parties would please state their appearances.
Your Honor, Ann Kinling, on behalf of the plaintiff appellant, Trust Women Foundation. Joining me today and who will be presenting argument is Gail Dede, who is admitted pro hoc vice.
Okay, thank you. And
yes.
For the appellee?
Yes, good morning. Brant Lau, appearing on behalf of the appellees Bennett and Schmidt. And we will be splitting argument with the Board of Healing Arts defendants.
Oh, okay. And who is in representing the Board of Healing Arts?
May it please the court, Courtney Sisman, General Counsel, appears on behalf of appellees Selzer-Lippert and Dr. Durrett.
And how we have 15 minutes. So how are the appellees splitting their time?
We have agreed to a split of 10 minutes for me to argue on behalf of the Bennett and Schmidt, and 5 minutes for the Board of Healing Arts defendants.
Okay. And Ms. Dede, did you wish to reserve any time for rebuttal?
For 3 minutes.
Okay, I'm sorry, I didn't hear you.
Can you hear me now?
Yes, I can hear you, but it's very faint. Go ahead.
I'd like to reserve 3 minutes.
Okay, got it.
Was that clearer?
Yes, that's better. So if you're leaning into the microphone, you might want to do that as you present arguments. Okay, so with that, we will start with.
Can I ask a question first?
Who? Yes.
Can I ask a question first?
Yes.
Ms. Sisman, were you on the brief for the Board of Healing Arts?
I was, Your Honor, under Courtney Manley. My name has changed since then.
Oh, I'm sorry. Thank you for noticing that, Judge Schroeder. I had not. So it's now CYZMAN.
Thank you.
Okay.
I just wanted to make sure I was correct. I understood the process.
Thanks. Okay.
Your Honors, if I can interject also, I was not on the brief for plaintiff appellant Trust Women Foundation.
Oh, okay. We had that you were. Okay. So all I need is you are Oh,
And-
yeah, that's right, because you just filed the entry instead of Robert I, right? And that's got your bar number and everything, and you filed that yesterday.
Yes, Your Honor, and I
Yeah.
filed an earlier entry of appearance as well.
Right, got that. Okay.
Thank you.
Thank you very much. I appreciate you clarifying that. Okay, so we start with the appellant, Ms. Dede, and you have reserved 3 minutes, and I will allow you a couple minutes before I start your time. Okay, go ahead.
You may please support Gail Dede for Appellant Trust Women. To go over the facts briefly, this case involves a challenge to Kansas statute section 65-4A10, which requires that a physician providing medication abortion be physically present to hand the pills to the patient. I will refer to this law as the in-person requirement. It effectively bans the use of telemedicine for medication abortion care. The law was challenged by another abortion provider and has been enjoined by agreed order since 2011. Appellant Trust Women is an abortion provider operating a clinic in Wichita. Trust Women began providing medication abortion by telemedicine in mid-October of 2018. It ceased that program on December 31st, 2018, due to a credible threat that the appellees here, the Attorney General, the District Attorney for Sedgwick County, and the Board of Healing Arts have authority to enforce the in-person requirement despite the 2011 agreed order. After a one-day evidentiary hearing, the district court below denied Trust Women a temporary injunction against the appellees Attorney General Schmidt and District Attorney Bennett. The district court also dismissed Trust Women's claims against the Board of Healing Arts defendants, Seltzer-Lippitt and Durrett, and denied a temporary injunction as to those board defendants as well. Okay. Trust Women asks that this court reverse the district court's denial of a temporary injunction against all appellees, reverse the district court's dismissal of claims against the board defendants, and instruct the district court to enter an injunction on remand. As we have all seen, telemedicine is an extremely valuable resource to our society. It has been proven to be extremely safe in providing a wide range of medical services, including medication abortion. Kansas law encourages the use of telemedicine for medical care that carries much more risks than medication abortion, including for treatments like diagnosing strokes. The only area where Kansas specifically prohibits telemedicine is for medication abortion. The in-person requirement challenged here is presumptively unconstitutional. Defendants concede that strict scrutiny applies, yet presented no evidence to try to rebut that presumption. Once the state failed to meet its burden, all of the other elements for an injunction fell into place. The district court nevertheless allowed defendants to continue enforcing a presumptively unconstitutional law and cause ongoing harms to Trust Women and its patients in violation of their fundamental right to decide to terminate a pregnancy and to equal protection under the Kansas Constitution.
Let me ask you one question, Ms. Dede. One thing that you have to establish is a cognizable an injury, and in order to get this injunction, basically we have to be able to find that, you know, continuing to enforce this law or enforcing this law is going to injure Trust Women. What should we make of the fact that arguably you could have been providing this since 2011, but were not I mean, although you weren't in business until 2013, I don't think, but yet you waited to challenge the statute until after the telemedicine statute was adopted and before it went into effect. So really from October to December was the time frame that you could have provided this. And up to that point, you'd never, I mean, you didn't seem to be injured by not providing it before. So what should we make of that? And I think the district court had some discussion about delay. What should we conclude from the delay here?
Trust Women didn't have a telemedicine program until October 2018. So Trust Women began providing abortion care in Kansas in 2013, but it did not develop a program for providing telemedicine until October 2018. So during the time before they began providing telemedicine, there's abundant evidence on the record that there were harms and delays being caused to Trust Women's patients. And Trust Women developed that telemedicine program specifically to alleviate the harms and the delays that were being, that its patients were being subjected to. And by credibly threatening to enforce the in-person requirement against Trust Women's physicians, Trust Women has been coerced into stopping providing telemedicine for medication abortion, and the harms that were occurring to its patients before that are occurring again.
Thank you.
So I'll first address the denial of injunction, and then I'll move on to the dismissal of claims. The district court's denial of a temporary injunction was a clear abuse of discretion for two reasons. First, Trust Women established irreparable harm as a matter of law. A violation of a constitutional right is itself an inherently irreparable harm, and it requires no further showing. When the district court below assumed constitutional violations, it should have concluded those violations were themselves irreparable harm as a matter of law. And second, Trust Women showed a reasonable probability of irreparable injuries even beyond the constitutional harms. For example, Trust Women presented uncontroverted evidence that Kansas's ban on medication abortion by telemedicine limits the availability of medication abortion appointments in its Wichita clinic, and those limited appointment availability in turn delays its patients in accessing abortion care. And those delays subject them to increased health risks and financial and logistical burdens. It pushes some patients outside the narrow window of time when medication abortion is available. And medication abortion is medically indicated for many patients. And for those patients, being required to get a procedural abortion instead of a medication abortion can pose increased medical risks that they wouldn't have incurred had they been able to get an appointment sooner.
So I have a question about the appointment setting. The Trust Women offer the service on Thursdays and Friday of each week.
Yes,
And all right, so why don't they offer the service on Monday, Tuesday, and Wednesday to make a broader window of time for people to come?
There's unrefuted evidence on the record that Trust Women has a very difficult time finding physicians who are willing to provide abortion care in Kansas. As a result, Trust Women flies in out-of-state physicians to provide care in Wichita. On the record, there were 2 physicians who were able to fly in. Those physicians were only able to fly in and provide care in Wichita 2 days a week, and those days were Thursday and Friday. So,
But the law is not affecting that because they have the ability to obtain other physicians, right?
here, Your Honor, with regard to how the telemedicine abortion ban impacts Trust Women and the harms that Trust Women's patients are experiencing as a result of it, Trust Women only has those limited appointments available because its out-of-state physicians are not allowed to provide telemedicine abortion remotely. When they were able to do that, when they began operating their program in October 2018, they saw that they were able to provide medication abortion appointments on more days per week, and that those appointments were available in more flexible hours, and that they took a lot shorter of a time. Despite these harms that Trust Women showed through unrefuted evidence, the statement produced no evidence refuting these harms. no one is suggesting the government is going to pay trust women and its patients for harms to their constitutional rights. And because these harms can't be compensated, they are therefore irreparable. Trust women and its patients are suffering ongoing irreparable harms, including violations of their constitutional rights, because of Kansas's prohibition on medication abortion by telemedicine. The district court's denial of a temporary injunction to alleviate those harms with a clear abuse of discretion, the denial should be reversed, and this court should remand the case with instructions for the district court to enjoin the district attorney and the attorney general. And that injunction should also be extended to the Board of Healing Arts defendants, whom the district court did not enjoin because the district court found trust women lacked standing to sue those defendants and dismiss the claims against them. And this was erroneous for two reasons. First, trust women has more than a generalized disagreement with the in-person requirement. The board's authority to enforce it personally impacts and harms trust women and its patients. It is uncontroverted that trust women stopped offering medication abortion by telemedicine out of fear that the board would suspend or revoke its physicians' medical licenses for violating the in-person requirement.
And Ms. Dede, do you have any cases to present to the court where, let's say, for example, a hospital is that the board set some sort of requirement for physicians that causes a hospital concern that they may not be able to keep these physicians because of the board's requirement? Are there any cases where a hospital has been allowed to proceed as an interested party against the board under those circumstances, either in Kansas or elsewhere?
Your Honor, I'm not aware of any such cases, but I would note that the situation here is different because trust women cannot provide abortion care without a physician. And trust women had only 2 physicians available to provide abortion care. And trust women, there's quite a bit of testimony on the record that trust women have a very difficult time finding physicians who are able to provide abortion care in Kansas. There are only 3 abortion providers in the entire state.
I understand that completely and appreciate that. My question is there any precedent for going to the standing issue? Is there any precedent, for example, because I could see perhaps a hospital or a medical clinic in some other area other than abortion being concerned about a new regulation that the board has adopted that may cause them harm in the same manner as you've been harmed. I just want to know if there's any precedent for this anywhere.
Your Honor, I'm not aware if there is precedent on that specific issue. I can speak to the fact that trust women's injuries here are causally connected to the board's actions, even if they flow indirectly from its threatened enforcement of the in-person requirement.
All right. Since we're talking about standing, as I understand the arrangement between the doctors and trust women, the doctors are independent contractors. Is that correct?
That's correct.
So they're not employees of trust women. Does that affect trust women's ability to assert the right of somebody else when they're not an employee of trust women?
That should not affect the trust women's standing to challenge the board's threatened enforcement of the in-person requirement here.
Why not?
Trust women, first of all, to establish standing, trust women needs to show a cognizable injury and also that injury is causally connected to the board's enforcement. Trust women here has shown that, first of all, it is injured by by the board's threatened enforcement of the in-person requirement, because that threatened enforcement has coerced Trust Women into ceasing its telemedicine program. And there is case law cited in our briefs discussing how the action, if the threatened enforcement by a government official results in a coercive effect upon the actions of someone else, that is sufficient for standing. And here in particular, Trust Women, the board's authority to enforce the in-person requirement doesn't need to be aimed directly at Trust Women and its patients for the board to be the proper defendant in this case. This is a pre-enforcement challenge, and there's a very clear connection between Trust Women, between the board's threatened enforcement of the in-person requirement and how that impacts Trust Women and its patients, specifically because if the board exercises their authority to revoke or suspend one of Trust Women's physician's licenses, that would seriously impact Trust Women and its patients, not just in their ability to provide medication abortion, but in their ability to provide any abortion care to their patients.
Okay, Ms. Didi, you're out of time. Are there any other questions from the panel? I'll still give you your rebuttal time. Any other questions of Ms. Didi for the panel? Okay, so with that, we will go to Ms. Is it Seisman? Is that how you pronounce? Or no, I'm sorry, Mr. Lau is next. Yes. Is that correct? Is that the order you wanted to go in?
Yes, that is, Your Honor.
Okay, so Mr. Lau, you have 10 minutes. Go ahead.
Good morning, and may it please the court. I'm Brant Lau, Solicitor General, arguing today on behalf of Attorney General Schmidt and District Attorney Bennett. This is a straightforward appeal from the denial of a temporary injunction. The district court's decision was not an abuse of discretion and should be upheld by this panel. First, there was no harm based on the facts as presented at the temporary injunction hearing. Indeed, there was not evidence that a single patient who was unable to obtain a medication abortion because of the law at issue in this case. I think it's also important to note that the district judge was in a bit of a quandary here. The judge was applying a brand new Kansas Supreme Court decision, as she alluded to in her decision, particularly at, I believe, page 24. The Kansas Supreme Court had decided the Hodes and Nauser decision only in April prior to her July decision. And in that case, the Kansas Supreme Court had said that no Kansas cases applying strict scrutiny to natural rights even existed. So the district court judge was being asked to break new ground, in this case, in the context of a temporary injunction presented at the very early and preliminary stages of the case. This is something that the Kansas Supreme Court itself referred to as a heavy task. It's the view of the appellees that this court should affirm, because the 4-factor test for the granting of a temporary injunction was not met in this case. The first factor involved a substantial likelihood of eventually prevailing. As I just indicated, the law is in flux on this issue, and it's not clear that the state would not be able to assert the appropriate state interests to meet the strict scrutiny standard. And in fact, that will come in the future in this case as it goes back to the district court and moves forward on the substantive merits. Second, as the district court explicitly found, there was no reasonable probability of an irreparable injury. The district court heard a day of evidence from 3 witnesses presented by Trust Women that were cross-examined by the state's attorneys. The conclusion after all of that evidence was that the patients of the Trust Women Clinic would still be required to come to Wichita 3 times, even for a telemedicine abortion, as they had been required under the prior procedures. Furthermore, as the district court noted out, and as one of your honors mentioned, the district court was troubled by a serious issue of delay in this case. A statute here that was initially passed in 2011, a business that went into began its practice in 2013, did not challenge the unconstitutionality of that statute until 2019. Now, there were triggering events along the way. The statute changed and was amended in 2015. There was another piece of litigation filed by Trust Women in 2018. But as of 2019, trustwomen, the appellants here, for the first time sought to undermine the statute's constitutionality after it had already been in existence for the better part of a decade. The district court relied on that, and we think quite properly so. Finally, we think that the public interest supported the entry of an injunction here. This is a statute passed by the Kansas legislature that is presumptively constitutional and should only be found unconstitutional in a preliminary or temporary injunction setting if the court has had a full opportunity to consider the facts and the law. As Judge Watson said, more evidence and legal analysis was going to be required to determine the constitutionality of this statute. And after a full review of the evidence that existed at this stage of the proceedings and the law, which, as I indicated, is new law, she found that a temporary injunction was inappropriate, denied it, and it's our view that this court should find that the district court did not abuse its discretion in denying the temporary injunction and should affirm the decision below.
Mr. Lau, I have a question. I'm not quite sure if it's completely relevant, but and as Judge Watson said, this has been just a backwater of litigation here. And this 2011 agreed, in 2011, the attorney, your clients agreed that they would not enforce the in-person requirement. Is that correct?
There is the
as it related
order,
to a
yes.
Planned Parenthood case, correct?
Agreed order from the 2011 case.
From the
correct.
2011 statute that you wouldn't enforce that. What's the status of that 2011 case?
So that case is still pending.
Why is that? This has been 10 years. Why is the 2011 case still pending?
I should note first that it was not a Planned Parenthood case. It
Oh,
was,
I'm sorry.
The case is captioned as Hodes and Nauser.
Oh, Hodes. Okay, I'm sorry.
Against Mosier. It was a Hodes case. That case is still pending on the agreed order. And I think part of what is at play here is, of course, the fact that the law changed in the interim.
Right, in 2015, but we're in 2021 now. I guess just as there's some concern about the delay on the part of trust women in pursuing this case, there does not seem to have been any rush on the part of the Attorney General to enforce this statute at all, because they've been sitting at least since 2011 and continued since 2015. They've been sitting on this agreed stay where they agreed not to enforce it. So what are we to make of that, if anything?
So when I referred to a change in the law, I was actually not referring to the change in the telemedicine or telemedicine abortion statute. I was referring to the intervening events in 2019 when the Kansas Supreme Court actually changed the law that's applicable to all of these cases.
Right.
And of course, that has required a new round of litigation in the other Hodes case, which is the case that went to the Kansas Supreme Court. That's the case where the Kansas Supreme Court put in place the strict scrutiny standard, but didn't define it and sent it back to the district court. So that's actually being litigated and has been litigated.
I guess my question is,
case.
why has there been no desire on the part of the Attorney General to enforce the in-person requirement at all? In fact, an agreement not to enforce it, at least until 2019, when this all started back up again.
Well, of course, the agreement there, we believe, applies to the parties in that case. The reason this case is because there are different parties, and when there was a demand made on the Attorney General and the district attorney to, in this case, agree not to enforce the statute, that was refused, and that's one of the bases on which trust women brought this case.
Right. Okay. All right. Any other questions of Mr. Lau? Okay. Ms. Seisman?
May it please the court. This case, as it relates to my clients, the executive director and the board president of the Kansas State Board of Healing Arts, is centered solely around standing. And the executive director and the board president are simply not the right parties to this lawsuit. Here, the district court was correct in dismissing my clients from the lawsuit for lack of standing, and we ask that this court affirm that decision. because Trust Women Foundation lacks both first and third party standing. As to the facts of this case and the relation to my clients, it's clear that there's no standing because no cognizable injury exists. And certainly, even if it did exist, there's no causal connection. As this court is well aware, judicial power is limited to actual cases and controversies. And part of that controversies requirement is that a party has to have standing to bring suit. And standing is a question of law. And so this court's review is de novo. For Trust Women Foundation to have first party standing against the executive director and the board president, they have to show that they suffered the cognizable injury and that there's a causal connection. For that cognizable injury, there has to be an establishment of an actual or threatened injury. Mere allegations of a possible future injury don't suffice, and that injury has to be imminently impending. Trust Women Foundation is not licensed by the Kansas State Board of Healing Arts. They are a licensed ambulatory surgical center licensed by Kansas Department of Health and Environment. Considering the board's enforcement authority, it's simply impossible for Trust Women itself to suffer any actual or threatened harm by my clients. And it's also important here to note the board has no enforcement authority over Trust Women Foundation's patients. Here, the district court noted, and it's important, that Trust Women sued on behalf of itself and its patients, challenging KSA 654810 and parts of the Telemedicine Act. It did not sue on behalf of its independently contracted physicians. Ms. Burkhart, the founder and CEO of Trust Women Foundation, testified that no complaint had been filed with the board against a direct employee of Trust Women Foundation. Additionally, no petition for discipline or CAPER proceeding has occurred in any way with any employee of Trust Women Foundation, anyone who contracts with Trust Women, or in any way associated with Trust Women and its clinics. The board's complaint and investigative and administrative proceedings process is briefed heavily and is in depth. But what's important to note in this process is that both the complaint investigative portion and the Kansas Administrative Procedure Act proceedings, and then the Kansas Judicial Review Act provide anyone who faces potential board action sufficient due process and a multiple potential resolution outcomes, not just simply suspension or revocation. Also worth highlighting for purposes of this case is that KSA 654810, which is the statute that effectively prohibits telemedicine medication abortions, has been in effect since 2011, a decade. And in this case, there's absolutely no evidence that the board has taken adverse action against any licensee for violation of the statute. Now, I do take issue with the concept that the board has threatened the physicians of enforcement. That's simply not true. What happened was the board was not going to agree to be a part and enjoy and not enforce the telemedicine medication in-person requirement based on an agreed order in a lawsuit that we weren't even a party to, that had been going on for nearly a decade. And Trust Women has tried to claim, that maybe its physicians are chilled by the board's enforcement authority over potential future board action, which is insufficient for standing. That argument was wholly dismantled by testimony at the hearing on the preliminary motions. Ms. Burkhart testified that Trust Women Foundation actually stopped providing telemedicine abortions on December 31st, 2018, due to their perception on advice from counsel that the Telemedicine Act, which went into effect on January 1st, banned telemedicine abortions. And it's important, it wasn't until after that date that Trust Women even contacted the board regarding enforcement. But even if, for argument's sake, that Trust Women has suffered a cognizable injury, the district court correctly concluded in no way was it connected to the board's conduct. To establish that connection, the injury has to be fairly traceable here to the executive director and board president, and not the result of some independent third party. Trust Women Foundation is challenging generally the constitutionality of statutes and the constitutionality of potential future board action. The record does not support any causal connection between the decision to stop providing telemedicine abortions and anything the board has done or failed to do. The theoretical potential for an administrative action being initiated by the board against the license of a physician who is independently contracted with them existed for a short period of time during October to December 2018, when they were actually providing telemedicine medication abortions. And here in this case, there's no evidence.
You've gone over your time. I'd like to give the panel a chance to ask any questions of you, though. Go ahead, Judge Schroeder.
I would like you to address the impact of Trust Women's standing to bring this case on behalf of their doctors who are independent contractors. Does that directly affect their standing, in your opinion?
In our opinion, it is certainly important. In this case, the independent contractors have not joined this lawsuit, and there's no suggestion that in any way they're hindered from doing so or bringing their own lawsuit in this case. But the independent contracted portion is significant in that they're not direct employees of Trust Women Foundation.
Any other questions?
Well, do you have any case law to support the fact that they're independent contractors limits the ability of the contracting agency to bring a case on behalf of them?
Not that is specific to this case in regards to abortion clinics bringing suit on behalf of their physicians or independently contracted physicians.
Okay.
All right, thank you. Ms. Dede, it is, you have 3 minutes of rebuttal.
I have 2 points in response to the Attorney General.
You're gonna have to speak a little louder, I'm sorry.
I have 2 points in response to the Attorney General, and then another 2 points in response to the board. So firstly, the application of strict scrutiny during the evidentiary hearing, what everyone was aware that strict scrutiny was the standard that was being applied before the hearing. There's decades of case law from federal courts as well as state courts that apply strict scrutiny in the context of an abortion restriction. Those were all known to all the parties. There was a full and robust evidentiary hearing in which Trust Women presented the unrefuted testimony of 2 medical experts. And the defendants had a full opportunity to respond to Trust Women's evidentiary presentation and presented nothing. They didn't call their own witnesses, and they presented not a single piece of documentary evidence. So this court has a full evidentiary record before it of ample unrefuted evidence supporting the presumption that the in-person requirement is unconstitutional, and the board did not, defendants did not meet their burden of showing that it is narrowly tailored to further a competing state interest.
Okay, so Ms. Dede, are you saying the state did not present any evidence on its own behalf? It cross-examined your witnesses, but the state didn't present any evidence in support of its position, any testimonial evidence in support of its position?
Neither, none of the defendants in this case called a single witness during the evidentiary hearing, and they did not.
Okay. Thank you. I just wanted to clarify that.
I'd also just like to briefly note that during that evidentiary hearing and on the record, there is ample evidence showing that the harms have resulted as a result of the ban on telemedicine for medication abortion, just even under Trust Women's protocols previously. And then in response to the Board of Healing Arts, I'd like to note that the board is investigating the only physician that has ever provided medication abortion by telemedicine in Kansas. That was one of Trust Women's physicians who provided when the program was in effect in 2018. So the harm—
And is that in the record?
The complaint is in the record, Your Honor.
Okay.
And to avoid misrepresentation, it wasn't just a complaint. And that the board's authority alone is enough to show standing. The board has authority They have refused to agree not to enforce the in-person requirement against trust women's positions. And they have in fact taken steps to enforce it that has had a coercive effect on trust women, and trust women has shown very clearly how the board's very credible threat to enforce the in-person provision against its physicians has chilled trust women's exercise of constitutionally protected activity of providing abortion care, has also impacted and harmed trust women's patients. And that is enough to satisfy standing, which is not a high bar.
And you are out of time. Does the panel have any questions, any further questions of Ms. Dede?
I do not.
Okay, thank you all very much. We appreciate your arguments today. They've been very helpful. We will take this matter under advisement and get a decision out as soon as possible. Thank you.